Matt, we're picking up your microphone. You might want to mute. There you go. Thank you. All right, and good morning. Welcome back. Our weekly session, our summer speaker series here at CASBA. Thank you again for joining us. I've really been looking forward to this topic. Matt, Calvin, I'll introduce you in a moment, but AB 5 was just such an interesting evolution from the Lyft and Uber bill all the way to affecting industries with some very unintended consequences, I think, as that was transferred over to multiple industries. So it's been a little bit complicated, to say the least, and we're looking forward to all of the clarity that you're going to be able to provide and share with our members on AB 5, specifically around navigating special education today. So a couple logistics before we get started. One is that the PowerPoint, the presentation and tools are posted in the Q&A session for you already. We will be having a facilitated conversation at the end of the presentation. You can, as we go, pop in your questions into the Q&A. Sarah Bachez joining us will be revisiting those with Matt and Calvin here at the end of the session, so that's available to you as well. And then this will be posted on our website. So let me introduce our talented team today. I'm going to start with our DWK team. Matt, an attorney with DWK specializing in special ed and labor law. Calvin Yang, thank you for joining us as well, DWK. Dannis Woliver Kelley, for those that are not as acronym oriented as we are. And of course, Sarah Bachez, our Chief Governmental Relations Officer here at CASBO. I'm Tasha Davenport, CEO. I'm turning it over to you. Thanks for being here today and sharing your wisdom and insight on this topic.
So, well, first of all, I want to say good morning to everybody and hope that those of you that are affected by the fires are in a safe place. And for those of you that are out of the smoke, I envy you. Up here in Chico, we are surrounded by it, and it's kind of bringing back some of those unfortunate memories from the campfire. The overlay, of course, with every training that we've been doing has been the shadow of COVID. And so when we have these discussions, what's interesting is this truly isn't a COVID-related discussion for once. We've had many, many discussions. It seems like what comes across my desk and what Calvin and I are working on are COVID-related issues almost on an hourly basis, which are ever changing. Which is helpful for our discussion today, because our discussion today in terms of what we're going to go through in terms of covering AB 5 is there is a lot of unknowns. As a lawyer, probably one of the most uncomfortable places to be is in the world of the unknowns. And that's because when clients call us, they depend upon us, as they should. And in my almost 18 years of practice, I know that when a client calls that they want the answer or the best answer. And what's interesting with AB 5 is for the few matters that I've worked on with clients for these is it gets to a point where we're saying, what are the best defenses? And that is the best answer. So in terms of what we're going to cover is I'm going to go over a little bit of the genesis of AB 5, how it came into fruition, an application of AB 5, and then the labor code section that was created from that. And then a discussion about the LEAs and then how LEAs could be affected by AB 5. And then, of course, future developments as we see things happen. So in terms of the genesis of AB 5, and if we were all in a room together, by the way, what I would say is I don't want to do death by PowerPoint. If any of you are participating right now that have ever seen me do a presentation, I like to keep things light and I like to have the interaction. So this kind of artificial way of engaging, I'm going to try my best to not just entertain you, but try to keep you engaged as best as I can for this very short amount of time. Sarah is going to be able to answer field questions, which we're going to do a Q&A on. So the best thing that I would say is as you're going through, as I say to all my teenagers that are doing their Zooms right now with their teachers, is write your notes down, make sure to capture them, and then you can ask them, and then I won't answer them. I'll have Calvin answer everything. Just kidding. So in terms of the genesis of AB5, what this was really known as initially was as the Uber or Lyft bill. That's basically how, like, when it first came to our knowledge, that's how it came about. And the idea is that these gig worker, independent contractors, online platform workers, contract firm workers, on-call workers, temporary workers, basically this gig industry, as we're saying, that's what drove this bill. I want to say, too, that as we all are familiar with in education, politics, right, played a lot into this. And when I say politics, I mean that in the real true formal sense of political action coming about to intervene into an industry that still really is developing, if you think about it. And then from that, then what did that mean for those employees? The other thing to contemplate is if you really, go down the proverbial rabbit hole of trying to understand AB5 and then the affected workers and just using Uber and Lyft drivers, those contractors, is did they really want to be affected, right? Were they even asking to be affected? Which also, as we go on to our analysis for LEAs, is for those that are contracting for LEAs, do they want to be affected as well? Do they want the benefit of having that contractor relationship, the independence, for example, that happens within these industries? So AB5 came about, was created, and then within AB5, once it came into fruition in January, and then came about, we had the application of the labor code section that was created, namely the ABC test that then came in. Yeah. So in terms of AB5 and the ABC test, this is going to be presented in reverse order. So if one of you were to call me from a school district, and if one of you were to say to me, Matt, I want to do an analysis of whether or not a certain, like an NPA falls under or doesn't fall under one of the exceptions of AB5. And the issue what I would say is that I wouldn't start with the ABC test you see analyzed here, but I want to start there because when we go through the analysis of AB5, that is the first thing that you will see if you go, for example, to the Department of Labor's website, and if you were to want to put in a request or a demand, if a wage earner did and wanted to, in essence, protest something or say that they weren't being treated fairly under AB5, the first analysis would be to go through this ABC test that you see set out before you. The ABC test, what it does is it presumes, there's a rebuttable presumption that right out of the gate that workers are employees unless otherwise proved through this test. So the burden that's interesting that is there through this is that right out of the gate, those workers that were as of December 31st, 2019, as of January 1, the rebuttable presumption is that they were employees and that you would have to prove it to the opposite. The ABC test, as I said, is clearly laid out on the Department of Labor's website. If you go into the AB, like what is AB5, and then is laid out before you. The big keys is for the ABC test. A is the person free from the control and direction of the hiring entity in connection with the performance of the work. Again, the tension there being, is the person truly independent, or are they really, do they really, walks like a duck, talks like a duck? Is it really that they're in that employee-employer relationship? Freedom, control, the ability to have freedom over your position is a big piece of that. The person performing the work, is it outside of the usual course of the hiring entity's business? This is a tension that you'll see when you just do by analogy with, for example, the Uber and the Lyft factor, right? you have a rideshare industry, a company, and they're contracting out for those drivers to perform the very business that they're in essence selling or putting out for public consumption. So again, the lines get very blurred. And then the third is the person is customarily engaged in an independently established occupation or business of the same nature of the work being performed. And again, not picking on Uber or Lyft, but using that as the way of, as an example, because that's what's in the headlines. It's what the AG pushed on the litigation that we'll talk about in a little bit later. But again, trying to pull this apart element by element to see whether or not there is that independence that's there. And that's kind of the key nexus that I see that goes through AB5 and the ABC test is how do you create in your analysis the division to separate employer or the business and then the contractor. So like everything it seems like we're doing these days, even with COVID, these issues are ripe. They are right here in the now. And in terms of the litigation, what's interesting, this recent litigation, and again, you might be looking at this and thinking, wait, I thought we were going to be talking about implications of special ed and AB5. Why are we talking about Uber, right? Well, the reason why we're talking about Uber is because when we're in the world of the unknown for a bill that was created politically and targeting specifically one area of interest, which is ride sharing, and it's Lyft and Uber. What's interesting is that this is not a piece of litigation that was created by somebody who was a wage earner or a contractor who is then receiving in turn monetary value for their work. This was actually litigation that was started and created by the Attorney General. Again, I'm going to bring up that word, political. So you have a bill that was created, then in essence being defended, although initiated through litigation, to then pursue and I guess you could arguably say uphold what was created within AB5. The litigation is still in development. It started in May, and in essence, what they're asserting is that Uber and Lyft have misclassified their drivers as independent contractors. So what they're doing is, what the AG is saying is, the Attorney General, what the AG is saying is, look, here's AB5, here's the enacting labor code. We're going to run the ABC test on you, and you're violating it, and we're going to take you to court. And so now the people, as of June 25th, moved for a preliminary injunction to enjoin the defendants. And of course, the defendants, being Uber and Lyft, have vehemently opposed this. So moving forward, like we do very quickly in everything that we do, it's pretty interesting to still be in the month of August and to be presenting a training on something where I'm literally learning live time as you all are, right? And then thinking forecasting, right? This is like a forecasting type of presentation, forecasting down the road, and then saying to ourselves, okay, again, how will this apply to me in my district? I'm in the HR department, or I'm in the CBO, working within the financial services or CBO. How is this going to apply to me? So what we're doing is we're using the steps that we're seeing happening in the Superior Court, and we're tracking it and then reading the articles, because what we're trying to do is we're trying to read tea leaves. What we're trying to say is, okay, if this is what's happening to Uber and Lyft through rideshare as an application of AB5 and the ABC test, what happens to us as a district, right, that is operating not as a business agency, by the way, as a public agency? How could that still maybe apply to me? So on August 10th, or really a long time ago, there was a motion granted for a preliminary injunction. That means it's putting a hold on everything from moving forward with regard to Uber and Lyft. And then there was an appeal that went up, and the Court of Appeal has in essence placed a hold and has said that Uber and Lyft can in essence continue to move forward, but under certain qualifying conditions. What's vague, what's happening right now, and this is really getting into the weeds, is what are Uber and Lyft doing right now, interagency, like within their business group, functioning group within the state of California. politically, what we've heard some wranglings, but we know what we've seen, if you've kept up on it within the papers online, obviously, is that Uber and Lyft are kind of saber rattling and saying things like, well, we're just going to leave then. We're not going to operate in California, which would create most likely a consumer crisis, which then might put pressure on the political side for the AG to back off. Not likely because of the pro-union stance and those type of protections that seem to be behind a lot of this. So again, it's kind of a wait and see at this time, and we will definitely be paying attention to where this goes as we anticipate it having an effect as a wave effect upon LEAs. So in terms of does AB 5 apply to LEAs, just by way of background, this first came to our firm as a issue, like issue spotting in terms of a matter that we had to investigate, do analysis, and then provide a legal opinion somewhere in the time frame of November or December 2019, as we were expecting the rollout of the passage of AB 5 and then the enacting applicable labor code sections. So within AB 5, what you have to do is you first look to the ABC test, and then you say to yourself, am I, or is the business agency that's operating, do we fall under the ABC test, or is there another part of the labor code section that applies? And by the way, within the materials that you have, and I don't expect you to read every single section of the labor code section, but if you wanted to go through it in more detail, is the enacting part of AB 5, which is those labor code sections. The reason why we give them to you is not just to prove that we've done our work to be able to present this, but it's so that if you ever want to go through those factors and analyze them in terms of how it applies to you or your agency, that you could do this work initially on your own. I would say though, and you know, everybody has their own counsel. This is a pretty sophisticated analysis. It's like academic meets intellectual meets kind of wonky, nerdy, like what's really going to happen in the future. And so as you go through that analysis, to the extent that you feel the inkling to reach out to counsel, I would advise it. And the reason why I would advise it is because that nobody, I don't believe, and then, you know, maybe somebody's on the line who is the expert. I don't think everybody has the answers as to, meaning the perfect answer as to LEAs and the application. So within AB 5 and the enacting section of the labor code is 27503. So the ABC test is the first part of the test to run through. And our analysis and the way that we're viewing this as a firm legally is that when you're talking about an application of AB 5, it is under a business-to-business contracting model that falls under what are called the Borrello factors. Now, notice that when I say factors, I'm highlighting on that because it's not a true litmus test. Factors, the way that we interpret it, is there's analysis, and it's not that every single piece of every single part of the letter of the law of A through L that are contained in the next 3 slides, that they all necessarily apply. And then if you fail part of one, then you have to revert back to the assumption that as an LEA, when you're contracting, that contractor is an employee. It's more of going through the practice of when you're contemplating whether or not there is that LEA employee or LEA contractor relationship. Are you trying to go through the analysis? I brought this up initially, but the first time that we contemplated this was a childcare issue where you had a third-party childcare agency operating on district campus. And so what they were asking is under the analysis of AB 5 and the ABC test and the Borrello factors, although that question wasn't even contemplated yet, you know, do we as a district need to be concerned about whether or not there is that relationship and whether or not there is an employee-employer relationship? So as you go through this these factors, what you start to contemplate is questions, right? You're asking yourself the question of, does the relationship between the agency and whoever is contracting in create more of an overlay? Once again, is there so much of a nexus that applies that you are now in the place of, in essence, somebody who is a contractor is really an employee? The first one is the first test under the Borello factors, and again, this is buried within the labor code, which is born out of AB5. Is the business service provider is free from the control and direction of the contracting business. So the first thing I want to, when we talk about all these issues, but with A, notice that there's this word of control and direction. It's almost freedom, right? Do you have the freedom to be able to operate independently? Does the contracting person have that ability? Or are they in such a supervisor type of role where they're being supervised, and in essence, they don't have that freedom? The other issue is that within 27503 and these exceptions or exemptions that apply under the Borello factors, notice that it says business to business. So if we were to be hit with litigation, let's say, down the road as an LEA, one of the first affirmative defenses, that's a defense that you put out legally, I would say is, first of all, and who knows if a court, would buy this argument, but one I would say is districts aren't businesses. Districts are actually, they're public agencies, they're a public entity. They're not selling anything. If anything, what they do as a good, so to speak, is they produce equitable, equal, fair, safe education for students, right? Which is FAPE, free and appropriate public education for all students. And that's entitled as a contract that's binding under the state of California under the Constitution. So one of the things that we would probably argue right out of the gate is there isn't a dispute because there isn't a business-to-business relationship. But this is what we have for now to weigh as our test. So that's just a kind of an introduction of going into A. Moving into B, the business service provider is providing services directly to the contracting business rather than to customers. Again, notice this language of business and customers. If we were to really push this to its extreme, does that mean then that if LEAs are part of this, that school districts or county offices or SELPAs, that they're considered businesses and then the students are customers? I think that goes beyond what we saw in the legislative analysis of what was discussed when AB5 was created. Nonetheless, this is the language that we have. And so as we go through this, that would be another affirmative defense that we would throw out there. But again, I think that's an easy hurdle to get through in terms of how we're contracting with independent agencies that that we're contracting with, usually through either an NPA or a specific contracted work where there is a set aside contract defining the relationship. The C is an easy one to satisfy, I hope, for most districts, because when I get a call about a relationship, whether it's and this is within special ed, something we recently had to do, we had to transport a student during COVID times from a state back east all the way to California, and it was transportation because the student was in a RTC, in a residential treatment facility, and had to be moved by car, couldn't get in an airplane. And so we created for a district, and a SELPA, a separate contract that was put into place. And of course, in writing, right? The biggest thing is establishing that business relationship. D, if the work is performed in a jurisdiction that requires business service provider to have a business license or business tax registration, business service provider is required business license or business tax registration. Again, I think this is a pretty easy hurdle for most LEAs to be able to get through, at least because most of us, when we have our contracting relationships within special ed, we are hopefully going along the guidance of through the SELPA having an ISA, an independent service agreement, that then has very specific language that exists within the contracting relationship. By the way, also, of course, there is the fact that and NPA itself is given life and the ability to be able to operate and the ability to be able to provide services, because CDE, of course, has its own requirements in terms of licensures, certification, those hoops that have to be jumped through. So again, D, I think, would be satisfied most of the time in most business relationships, again, so long as what is in writing also shows that they're meeting this business service licensure requirement. For E, the business service provider maintains a business location. This sometimes gets blurry. Right now in COVID times, this might be very interestingly blurry, right? So if you had a contracted NPA or a solo practitioner who's providing contracting services to an LEA and they're operating out of their home temporarily, how blurry are the lines there? If we were to suddenly be hit with a wage or benefits challenge by somebody who during these COVID times has been providing contracting work and we didn't have anything in writing, how much of hot water would we be in under an AB5 analysis? I think that could be pretty problematic. Generally, though, what I have found is that NPAs have their own brick and mortar, the pre-COVID time talk, but they have their own brick and mortar building where their employees would go and report. They would work on their reports, etc., independent assessments, data collection, those kind of things in an office. Again, a hurdle that I think can be pretty easily overcome. F is that the business service provider is customarily engaged in an independently established business of the same nature as those involved in the work performed. Again, when we're bringing on, generally speaking, contractors through districts and it's business to business, if it's, for example, an NPA, they're providing a service, but it's a service that's very specialized that we need, that is to provide specialized service for our students under an IEP, which is, by the way, an IEP I've always looked at as a contract too, because you're saying the student is going to be provided with program placement and services for this duration of time. We're held to it by law, and it's a promise in terms of what will be performed. All right, and then the last part of the Borello factors, I hope you're still out there and awake. I know that this is really exciting stuff to go through Borello factors between 10 and 11 on a Wednesday, but you're going to have now all the answers for everybody else across the state, and nobody will even have to call me. Going on into G, the business service provider actually contracts with other businesses to provide the same or similar service. I think generally speaking, this is another easy hurdle for LEAs to get past in terms of this analysis, in the sense that the services that are being contracted are like services that other districts receive. There isn't something, generally speaking, unique that we will receive that others won't. There are some times where there are services that are provided in districts within counties. For example, during the campfire, post-campfire, with the horrible devastation that happened in Paradise, there were, and this is just an example, there were therapy dog services that were contracted, and through either the county or directly through the district, there were those therapy dog canine services set up so that the animals could be there to support children that were returning back to either new school sites, mobile type of sites, and that was part of a service that was being provided. So you might be able to say, well, that's very unique, and so then therefore you couldn't get past the hurdle. I think that you could, because you could say it's part of kind of the educational and also mental health services that we're required to be providing as LEAs. For H, the business service provider advertises and holds itself out to the public as available to provide the same or similar service. Again, I think that what you have to do with this distinction is when the business service provider, and again, just using an NPA as an example, they, generally speaking, put themselves out there as providing a unique specialized service that they are providing to supplement the program, or to be able to provide services that the district cannot. A classic example, of course, is something like speech pathologists. We know that statewide there is a slowdown, there's a lack of speech paths throughout our state, and so then there's NPA agencies that then hold themselves out of being able to provide those similar type of services, but they're providing it in a manner that is to supplement or assist the district because of a lack of service or ability to be able to provide their own service by the mere fact of not being able to employ those individuals. I, as the business service provider, provides its own tools, vehicles, and equipment. This gets into some pretty specific things, and when I've had this discussion in the few cases that we've done this analysis, it gets a little tricky because there is the issue of when you arrive on campus or you report to your site to provide certain services as the NPA contractor or NPA employee, do you get into a district vehicle and do you drive the district vehicle? Do you get into a district vehicle and in essence ride share within the district? Does the district hand you a cell phone that's their cell phone and you're using their cell phone during in essence your contracted relationship? What about emails? When you start to onboard, when you're onboarded and you onboard one of the NPA contractors, how does their name appear in terms of what's listed so that it's very distinct that they are not a employee, but they're a contractor? Within the materials, and I'm going to talk about this later, but I'm just going to bring it up now. Within the materials is a very draft, simple, easy template, but it's just to kind of trigger the thought as a learning tool for us for now is as you're onboarding people, bringing them on, bringing them through, the contracting relationship, and it's the individual making sure that they understand that there is a distinction between other employees and them as a contractor. So again, another hurdle to get through. J, the business service provider can negotiate its own rates. For NPAs, I think this analysis is easier because the NPA has to establish the relationship through an ISA, which is an approved form through the SELPA. Where it gets trickier is where you have a solo practitioner who is directly contracting with the district and what that contract looks like. And if somebody were to call me, after this call and it was a client and were to say, "Oh, Matt, I listened to your CASBO talk, and we don't use contracts for certain individuals that work with us." And the first thing you could probably imagine I would say is let's get a contract. Let's get something establishing that partnership, that relationship, and not just for an AB5 analysis. It's really also for a liability analysis of clearly outlining the expectations and the scope of the work of the business. And then K, consistent with the nature of the work, the business service provider can set its own hours and location of work. I think this is where another area similar to I, which is the tools, vehicles, and equipment. I think this is an area that sometimes gets blurred because you have individuals that are contracting, and I just happen to know, and I'm not picking on speech paths. My mom was a speech path, and then she worked for an NPA, and so I know what that business relationship looked like. A lot of times what happens is other employees don't understand the relationship, and so then the lines get blurred there too. So you could be sitting in an IEP team and you could have a speech path who's contracted in through an NPA, and they might not understand the difference of the relationships. And certainly if they don't understand the difference, then how could maybe even that own individual contractor not be confused? So in terms of making sure that the hours worked, the location where you're working, certainly the district, the LEA itself can be saying, this is when we need your contracted, for example, speech path to be reporting for IEP meetings, data collection, those sorts of things. But in the end, ultimately, that supervision responsibility is with the NPA itself and is not with the district or LEA. Another area where this could get blurred is in the area of discipline or intervention or supervision. And I think, again, we need to be careful that as we have these contracted employees, that we still are working with, for example, our NPA to say, we have this issue with your contracted speech path. And we need to talk about issues that we're seeing in intervention, and that it's, the district, for example, HR department working with the NPA and their supervising wing or management to work on those issues. And then L doesn't apply, but it is within the factors, but that relates to contractors within the state licensing board itself. So it's not normal that when we're working on these kind of slides, we put like an all caps for a word in a subheading. But I'm putting that there with emphasis on potential, because again, I believe we're treading still on unknown territory. There isn't, I have not seen like a specific carve out, for example, with an AB5 or even any analysis yet, other than our own legal analysis that we've done on within AB5 and then the enacting labor code sections, all of the pitfalls that might be out there, or the liability issues that might be out there for LEAs. But and I know if we're in a room together, we could actually have a discussion. I could throw these out there and then you could give me your thoughts back. But these are the areas where and there's more that's even listed here, but these are the areas where I could see issues coming up. So the first would be, and this isn't special ed, but I think it helps by way of analogy, when you're offering stipends, for example. Now, stipends, as we know, under most CBAs, collective bargaining agreements, these are covered areas where if you are in the certificated unit or classified unit, it's clear that the contractual relationship is dictated by usually an addendum or an exhibit or an attachment to the CBA itself, and then it outlines how that stipend contractual relationship works. What we're talking about here as an example is the walk-on coaches. So if you have a walk-on coach, if you have a specialized art, provider, teacher that's coming on to provide services, we've seen dance instructors, music teachers are even being contracted at times because they don't fall within the unit, or they don't have the capacity to be able to provide a full-time person in these positions. These are just examples of stipends that could be out there that could then create that kind of AB5 analysis. The next, and again, these are just examples of areas where we could see concerns arising. Also, contract for nurses or medical care services. And again, this is where a nurse is not a part of the certificated unit, or individuals providing, let's say, LVN care that are typically under the classified unit or under CSEA. This is where somebody is providing acute services, and where you're contracting them in, and it might not be through an NPA. It could be through a separate agency. And again, what we want to be looking at is, what is the contractual relationship that is there, and what are the services that are being provided, and is it clearly delineated in the agreement, the contracting agreement, what that relationship is? Meaning, does the contractor have that independence we were talking about, right? Do they have their own vehicle? Is there a clear distinction between the LEA and then that contracting relationship? Going back to stipends, the same thing. Within the hiring of any of these individuals, and I'll just use coaches as an example, I've seen outdated forms as I'm sitting at the bargaining table and we're working on negotiations, and as we're going through negotiations where, in terms of athletic walk-ons, that it's not clear, for example, what that stipend contract looks like per year, and that it's renewed each year. What I would be worried about is a stipend. It's being provided. There's no contractual relationship that's out there that clearly delineates that. Another area that just to be mindful of, and especially right now during these COVID times where districts are, and I'm happy to see this, by the way, but districts are and LEAs are being very creative with after-school services or childcare services, making sure that, again, there is a clear distinction between what is LEA-related business and what is business that is related to what's being provided. So child care services or child enrichment services, that the scope of that is defined, that when you have an agreement between the agencies, that it's clear that the use of the property, how that's being used, and so forth. In the special ed world, we bring in expert witnesses or experts or independent assessors all the time. This is something that routinely happens as we get into special education litigation. For the experts that come in and they're, by example, brought in through our firm, most of the time we will have the contracting relationship. So there's probably not an AB5 tension that could arise. Where we're seeing that there could be that AB5 tension that could arise is the district brings in their own expert or independent assessor separate from an IEE. This is where you're bringing in somebody to get a second opinion, right? Maybe you want to bring in a school neuropsych and you want to have them look at your program placement services offer, do a file review, those type of things, and maybe not even litigation, but you just want to make sure that what is being done is proper. Again, what I would encourage under a defensive AB5 analysis is, and when I say defensive, I mean if the litigation were to come, what could Calvin and I put into the papers to say these are the things that you should be that we've done to clearly establish those relationships. And then again, for more examples in terms of special education and then service providers, we know that this list goes on and on and on. Transportation services, speech paths, I've already talked about, OTs, PTs, school psychs, other type of like behaviorist aid supports. A lot of these are services that are provided, whether through the classified unit or through the certificated unit, but sometimes because of employment shortfalls or the specialty of the position. I'm thinking about like a behavioral aid, for example. When those providers come in and then provide those services, what I would encourage is you is to, when you go back to your desk, although you're probably still at your desk and you're not going to leave your desk, but when you return and you're with your colleagues or you have a conversation, is analyzing these relationships, right? I know many times in the 17 years, I guess, that I've been an ed lawyer, specifically within special ed, where the student can no longer ride the district provided bus, for example, and the student has to then be provided with private transportation. And I know you, as CASBO, you probably have already had a lot of this discussion, but just as by way of example, I think that sometimes what happens is we take the most defensive route, which is good because we have to pick, in essence, what our fight or our litigation is going to be about, and then we provide the private transportation. When you do that, if you do, once again, you want to make sure that you're establishing a clear line delineation of what does that private transportation look like, and that it is a for contracted service. We've done contracts where we've taken an ISA as a model and then used that to then create a transportation contract for very specific services for students. The learning pods are coming up right now, as we know, but learning pod tutors that could come in, we could see an issue again with those relationships. Substitute teachers, again, there's usually a contract. It either goes through the district or it goes in the HR department, or it goes through the county office itself. But again, making sure that those forms are up to date. What do those forms say? And again, just making sure to clearly delineate the relationship, the business relationship. And then again, these are, I think we've covered all of these, that solo practitioners, private practice, NPAs. And again, I think that in terms of the effect and how does AB5 affect these, again, I think what we have to be looking at is what is the service that's being provided, and then with what's in being provided, what is the understanding of the business, of the relationship between the LEA and the contracted worker that's providing the services, or the NPA that's providing the service. So again, there was a disclaimer, and Sarah reminded me to make sure that was included within our slides ahead of time. And all joking aside, I say this when we're doing our presentations anyway, but we're very clear, right? When we engage in these kind of platforms, whether we're in person, hopefully someday again, or even interacting in this way, this isn't free legal advice, but this is our best analysis of advice. Ultimately, you would want to, when working on, especially I would say cutting edge issues like this, you'd want to consult with legal counsel. And within one of our districts that we work with, we're contemplating this exact issue, which is for sample ISA language, meaning independent service agreement language, what additionally should be in there. Again, if you didn't have it in there, would you be able to defend yourself if somebody went to the Department of Labor and filed, for example, a wage dispute or a benefit dispute? I think that if you went just through the Borrello factors alone that we covered, I think you'd be safe. But what we're thinking about now, we're contemplating is what's the add-on? What are the other things that we can be doing to make sure to enhance the separation, or enhance the ability, the knowledge to know that nexus is far apart, and that there is a clear delineation between LEA and then that contracting agency. I am not going to read this language that's there. You can see that it's there. It's been carefully crafted. It's an example, though, of a way that you can put into an agreement that delineation between the LEA and the contracting or the contractor, or the NPA itself.
Sarah's going to take us into questions, but gosh, Matt, Calvin, thank you. It really, one word that came through and resonated was around contracts, just making sure we understand the relationships that are out there and that we are creating, and actually getting some specificity to those in terms of a contract. So thank you, Sarah. I think we've got a lot of questions over here, and thanks for facilitating the Q&A.
I'm going to let Matt finish the future development.
Right. Thank you. So again, this is illustrative. This is in no way, and it's really, again, reading tea leaves, but it's the issue of in future developments and forecasting down the road. Where do we see things developing? Much like the litigation that we were talking about in the beginning, which seems to be affecting certain gig industries. But Uber, Lyft, rideshare, and others. Proposition 22 specifically is targeting, from an advocacy standpoint, the defense of the ability for rideshare, those gig industries, to be able to exist still in a contractor relationship. Again, very political. The winds of change are going to be moving back and forth. We are going to follow this, though, and I would encourage you to, as you're reading all the different news articles or whatever that are out there, to follow it, because there could end up being other rider language that could go into other bills. AB 2257, which Sarah and I have talked about, is another one that's out there that could end up getting to the governor's desk. It may not change much, but again, it could slowly open up that door to then anticipated liability that we need to be looking out for. I think I covered this, but again, just the issue is for this is, well, another issue I should say for this is the issue that there's litigation pending. There's a proposition that could change the landscape, and then in addition to all of that, you could have an enhancement through AB 2257, bringing all of these issues either into loggerheads, or maybe we get a solution. So we'll see. All right.
So at this point, I'll begin. The first question's towards me, and I'll take that one on. And while we do that, if for folks who want to raise their own questions, we have a hand raising feature as part of the WebEx webinar, and you're more than welcome to use it. Michelle will let us know if you're on the queue, so you could ask your own question. First question that has come into the system is, has CASBA considered, and I'll ask Matt to, yeah, thank you. Has CASBA considered asking for an exemption from AB 5 for public education? And the answer is yes. When AB 5 first was introduced, we worked with AXA to make sure that the author's office was informed, the legislative leadership, as well as the governor were informed of the vagueness of the language, the unclarity and specificity in terms of, we are public agencies, we are not business to business, we should not be we should not be impacted by this. Because at that moment it was really political and really tense, and the focus really was on the transportation companies, not public health public agencies. It was really difficult to get any traction moving. Now, as we're seeing legislation from various sides on exemptions for different job titles, journalists, musicians, hair salon, hairstylists, barbers, a lot of different industries have come forward and explained that this is going to affect their industry and their profession. For schools, because it's still such a gray area and we have not yet been tested, leadership is not willing to go in and provide a carve out for us. And it's also very political. And so if you open one thing up, it makes it very dicey on who's going to ask for a request. And so for us, we've just kept the pressure moving. We are working very diligently with AXA on this matter, making sure that people understand, because of the vagueness and because the unclarity, it does put LEAs in this precarious situation. And we do not want you to be in that situation. So this is an issue that we've continued despite it having been enacted in January. And it's something that, as we start seeing the implications and hearing from our memberships directly, that information is useful for us across the street in the Capitol. So the first question to Matt and Calvin: can we hire consultants in the business services due to shortage of staff because of COVID? Can we hire consultants to assist in the aspects of fiscal services such as payroll, closing of the books, budget analysis, etc.?
Okay, I'm unmuted. This is a tricky question, and it's tricky due to the fact of the first thing that came to my mind was the interlay with the unions. So specifically, I would think within the classified unit itself, and whether or not, for example, CSEA or others. Can you hear me okay? I just want to make sure.
We had a momentary issue, so go ahead and start. I think you're back.
Okay. In terms of hiring consultants, again, I think is a tricky issue, and I think it's tricky. The first thing that came to my mind from the labor standpoint was, if you were to bring in these other short-term employees, would you have to then negotiate that? I think that you may have to, and something I would consider is consulting with the unit, specifically classified unit, most likely, to talk about how these contracted workers are going to be coming in. They would probably fall under the short-term employee status, which with these one-time dollars that are out there right now that we know expire on December 31st, that they could be used in that manner. On the other side, if you said to me, can we, but you changed it to, Matt, I'm going to hire in these consultants under a contract relationship, and so what do I need to do, right? So not can I. If you were going to say you were going to move forward with doing it, I would say make sure that it's very clear, once again, what those contractual relationships are. That they're being brought in under one-time dollars. When you onboard them, that you have onboarding forms that clearly outline what the expectations are for their work, and that they're providing a very unique and specific type of service to your LEA. Having just went through at the bargaining table, though, within the classified unit, the issue of one-time dollars, these one-time dollars being spent on very specific needed areas. The flag that I would throw up is I would make sure, like, if this question from, if it's Madeline, if I'm reading that name right, hi Madeline, if it's coming, from you in the CBO's department, financial services, you're definitely consulting with HR to get their take on that, because I could see that tension coming up.
Calvin, did you have something else to add? If you hire an agency instead of a specific person, and the specific person is an employee of that agency, do you have to worry about AB5?
I think that by reading into this, if we hire an agency, so that means that in essence you would be going the NPA route, and then that NPA is providing a specific service. And again, I'll just use speech as the example. So you're bringing in a speech pathologist, and then that specific contracted or employee of that NPA is providing services. I'm not as concerned with that. But again, rather than the way that the question's asked, how I would change this a little bit to make it more complicated is, I get a phone call, Matt, we've brought in this NPA, but our ISA is outdated, or our ISA doesn't include any protective language that clearly delineates the relationship. That's where I would be more concerned in terms of that relationship. I mean, the business relationship. I mean, the two questions I've seen so far already, these are like, analogy to my high school kids, like these are AP level class questions. These are my honors type of questions. And for those, that means that you are already thinking way ahead. And when you're thinking way ahead, then you're anticipating the defenses, like we talked about before. And not defenses from a negative standpoint, defenses from a standpoint of being able to say, this is what we did to clearly lay out what the expectations are of the business relationship between the two agencies. So for Sandra, I think yes, I think you'd be safe, but with a qualifier of making sure that you have a clear business relationship set up.
Will this language, and I'm wondering if that language is reference to the paragraph you had towards the end of your presentation, be available somewhere to use this language on contracts?
Yeah, so within our materials, we created some exemplar language within an onboarding form. An onboarding form is something that I have not been able, and I would love if, maybe if those that you are participating, even if you have your own, if you might be willing to share those with Sarah or Tasha. But when I say onboarding forms, to be clear, this is more from like the HR perspective, but sometimes through business services, which is I'm bringing this individual into my agency, and I want them to understand, like, do they have keys? Have they done their W-2? Like all of those different things for onboarding. What I'm trying to do is create an artificial way of when that business relationship is being set up, that it's clear and delineated. So within that onboarding form, and it's fictional at this point, but it's an example of something that you could use. So you would have that form. I love forms and I love contracts. And the reason why I do is because then I have proof to defend you down the road, right? So if any of you are out there I'm not working with yet and I get to work with you in the future, one of the things that we will work on is creating those kind of forms, or looking at old forms and saying that last date that was revised was 1997. Let's get out of the 90s, right?
I kind of want back in the 90s.
I know, that's true. I want the 90s back. That's true. You're right, Sarah. I apologize.
We have a hand raised by Sana, and I apologize if I don't pronounce this right. Sana Preston. You can unmute yourself. Ask your question.
Hi, yeah, this is Jana Preston. Thank you. My question was, if we are using independent assessors who are mostly solo practitioners, is to be compliant, do we need to hire them as part-time employees, or what would be your recommendation?
So in the slides and in our discussion with regard to that direct contracting relationship, I think that you would want to, again, make sure that you set up a contract that then outlines the expectation of the services to be delivered so that it's known the time, duration, frequency, and in terms of compensation, what that's going to look like so that you're establishing that differentiation. I think you would also want to define the term and the scope of the services to be delivered. And I think that can, if you do that, if you want to set it up as a separate business relationship so that they are a contractor, I think that you're well within your rights to be able to do so. I think that if you don't have that protection of that contract, two problems come up, not just an AB5 analysis, but the issue of not understanding the employment or contracting relationship. How am I going to get paid? Who am I delivering services to? Why am I delivering these services? Who is my supervisor? Those kind of questions. If you were to say to me, could we bring them in as a employee? I think you could, but again, I think that you bring in that discussion then of a discussion between the HR department and then financial services, because then are you then actually bringing in a short-term employee who maybe isn't classified yet within either unit, and so you'd want to make sure to outline that.
And I know we're running out of time, but I think there's a really good question, so we'll go ahead and ask it. Given that NPS and NPA are governed by a master contract specified in Education Code Section 56366 and the Title V regulations, which is a more specific statute applicable to LEAs, would this support that NPS and NPAs are not subject to AB5?
Yes, I have done within our office, Calvin and I have done an analysis of NPAs, not so much for NPSs, but I can tell you what my legal analysis is and opinion on this, which is that under the Education Code, but then actually also under Title V, and then the other layer is the licensing or certification process through CDE. If you go to CDE's website and you just search term NPA, it will give you the not just the definition, but how you apply as an NPA to be able to provide the services. I think that all of those overlays give you that AB5 protection. So then you could say, well, then why did you do this presentation, Matt? The issue is that when you have that relationship, making it very clear that there is that separation. So if it's, I think it's Lisa, Lisa, to answer your question, I think that you would be safe under AB5. The answer would be yes. But again, the lawyer in me that wakes me up at 3 a.m. sometimes is making sure that you have that written protection, kind of as an insurance clause in place.
And with that, thank you so much, Matt and Calvin, for your time, your attention, and all of your great information. Their contact information is listed below at the end of your PowerPoint presentation. Thank you so much for attending our session. Have a great day.
Thank you.